I'd like to welcome all of you to another seminar of our Legal A to C NGO series. Those who attended the first seminar might remember that it was about how to set up NGOs in India. We discussed issues such as legal and tax compliances, FCRA regulations, and fundraising solutions. And that seminar inspired us to develop a handbook as well on these topics, which is up on our website. And the videos of that seminar is available as well. I'll be sharing the link for that on the chat box soon, so you can access them. As the second part of this series, we have organized the seminar today on good governance. Before we begin, I'd like to take just a few minutes to introduce iProbono and our speakers for today. Shalinti, next slide. iProbono is a social justice organization whose mission is to enable people to access their rights. Our work in India began 10 years ago, and since then we've expanded to a number of different verticals, focusing not only on litigation, but comprehensive care, advocacy efforts, and strengthening civil society, which is one of the core verticals. And in itself, it has various elements to it. The first being direct legal support to NGOs, where we provide free legal advice to NGOs through our community of accomplished pro bono lawyers on legal advice on regulatory compliances, drafting of contracts, and intellectual property disputes, and so on. We also organize many capacity building initiatives like workshops and trainings on laws, social justice issues, and best practices for various different stakeholders like NGOs, lawyers, social workers, communities, educational institutions, and government stakeholders as well. And our team ourselves conduct training on internal policies such as sexual harassment at workplace, gender sensitization, child protection policy, as well as on legal and organized national compliances. Besides this, we work on knowledge development and legal education, under which we develop and publish easily accessible resource materials, including toolkits, handbooks, case studies on different subject matters like child protection, right to information, legal compliances, and the Legal A to Z handbook is an example of one such resource. And in our attempt to empower the communities, we are trying to develop written and video materials in local languages as well. So if any of the NGOs present here requires any legal support or would like a training, please feel free to reach out to us directly or through our website. Again, I'll quickly take you through the other verticals of our work. The other core one being litigation, where we engage in direct legal representation in courts. We currently have about over 95 lawyers on our panels in Delhi, Mumbai, Bangalore, Kolkata, Jaipur, and Jodhpur. We work on cases of child protection, mainly child sexual abuse, housing rights, and other social justice issues. In Delhi, we also have 2 social workers in our team who provide psychosocial support to children in need of care and protection and their families. And finally, we also engage in targeted research and policy advocacy, such as making submissions to parliament committees and court committees, and working closely with government agencies. I will now introduce our wonderful speakers for today. First one being Mr. Noshir Dadrawala, who is the Program Director of Legal and CSR Compliance at the Center for Advancement of Philanthropy. Noshir is one of the sector's foremost consultants on legal compliance for nonprofits and corporate social responsibility. He has a very diverse and deep understanding and experience of the law, matched with the practical background of consultations with over 1,000 nonprofits over the past 32 years. Thank you for joining us today, Noshir.
Welcome.
The second speaker for the session is Mr. Anil K. Goyal. He is the founder and the principal partner at Anil K. Goyal and Associates, which is a firm of chartered accountants. He has 35 plus years of experience, and his core areas of expertise include FEMA, company law, strategic and corporate consultancy for businesses, and offshore structures. He has clients in over 25 countries and is also a fellow member of Institute of Financial Accountants and a fellow member of the Institute of Public Accountants in the UK. Thank you for joining us today, Anil.
Thank you, Priya.
We are so grateful to have both of you conducting this seminar, which I'm sure will be very helpful to all our fellow partners from the development sector. I'll also like to give everyone an idea about the structure of the seminar and certain housekeeping rules. We will start with Noshir, who will be talking to us about the different types of nonprofit entities, powers and responsibilities of their governing bodies, and best practices on good governance. Then Anil will be taking us through essential compliances for NGOs, especially those related to finance and tax. We aim to keep the last 20 to 25 minutes at the end, that is post 5:30, for an interactive Q&A round with Noshir, Anil, as well as Benita, who is our operations director at iProbono. And I know a lot of you have already sent in some questions with your form, which I will ask the speakers first. And then anyone from the group can raise their hand, unmute themselves and ask their questions, or they can put their questions on the chat box. But I request all participants to please keep their mics on mute, except during the Q&A round, because this seminar is going to be recorded. And post the seminar, we'll be sending everyone a feedback form on email, and it'll be helpful if you can share your response there. With that, I thank all of you for joining, and we'll hand over to Noshir now.
Thank you, Priya. May I have my PowerPoint up, please?
Yes.
Thank you, Priya, for that introduction, and I'm most delighted to be in your midst once again. I have had the pleasure of addressing some of you a while ago, probably a year ago or so. And I'm glad that this time I also have Anil as my co-panelist. So together, we should be able to take care of a lot of your queries and doubts that you might have. Last time I spoke to you was largely with regard to legalities surrounding FCRA and yes, about income tax also, which Anil will be covering more in detail today. And about today, it's a more specific topic that I'm covering, and which is good governance. Now, good governance is also about legal compliance, but this particular reference here is to good board governance in terms of where the leadership of your organization is concerned. What constitutes good board governance? So that's going to be the focus, but I want to set the backdrop for it before I come to board responsibilities, board roles, etc. It's important for you to know different structures and how it can be little bit at variance under different structures. So may I have the next slide, please? So first of all, I think a quick revision of what we had done even earlier, that, I mean, many of us consider ourselves as NGOs, NGOs meaning non-governmental organization. The term has been coined because we are essentially doing government's work without being a government, and therefore we are referred to as non-governmental organizations. Some prefer to call themselves PVOs, that is private voluntary organizations. Across Asia, the term used is SDOs, which means service delivery organizations, providing various services, be it in the field of education, healthcare. Unfortunately, in India, because of GST laws, the goods and services tax, it's a term that we avoid using because you're kind of saying that you are some kind of a service provider. CSOs is used commonly in India, which is civil society organizations, which are largely advocacy groups working on policy, etc. And of course, CBOs also, which are community-based organizations that work in various communities, geographic communities, local communities, etc. But the important point I want to reiterate once again is that none of these have any legal meaning under law. NGO, PVO, SDO, CSO, CBO, you have to, for the purpose of income tax requirements, for FCRA requirements, have to exist for either a charitable purpose or a religious purpose. Charitable purpose has been defined under law. Anil will probably dwell upon that. It's very clearly covered under Section 215 of the Income Tax Act. What is charitable purpose? So more about all that in Anil's session. May I have the next slide, please? So the term foundation is also that I am going to be on the board of a foundation. Now, in foundation, most of the time in India, we seem to think that foundation is a grant-making body. It is not. I mean, foundation is again a very colloquial term that we use. It's either prefix or suffix to the name of your organization. In the United States of America, the term foundation has a meaning. There are family foundations, there are corporate foundations, there are community foundations, and there is a whole taxonomy of these foundations. But in India, the foundation means nothing. And if you think foundation means you are either a society, or if you think foundation means a grant-making organization or a corporate foundation, the answer is no. I mean, some of the best-known grant-making organizations like Tata Trust are called Tata Trust. They are not called Tata Foundation. Mahindra is KC Mahindra Trust. It is not KC Mahindra Foundation. So foundation is essentially an Americanized term, which we kind of like, and we tend to in at least modern times. And so you have the Azim Premji Foundation, you have the Infosys Foundation. So foundation has become more in vogue. It's a nice Americanized term that we like to use, but it has no legal meaning in India. It's either prefix or suffix to your name, but foundation means nothing. So if you say, I want to set up a foundation, well, the foundation again has to be either a trust society or a Section 8 company. Foundation means nothing really in legal terms. Next slide, please. So yet another term that we have, social enterprise. Now, social enterprise is likely to get some kind of social significance because the term social enterprise is now recognized under the social stock exchange. As you know, the Bombay Stock Exchange has already started the social stock exchange, and it is now even open for registering, not for listing, etc. yet. But I mean, organizations that wish to register on the social stock exchange, there the term social enterprise has actually found meaning. But again, a social enterprise can be non-profit, and if you're a non-profit, you got to be a trust society or a Section 8 company, or you could be a for-profit social enterprise, and you could be a private limited company, you could be an LLP, you could be a public limited company. But the term social enterprise will actually have a definition, or it already has a definition, I would say, under the social stock exchange, which has been initiated from this year. At least the one on the Bombay Stock Exchange is now alive. We can talk about it more later if there is time and inclination to discuss this matter. Next slide, please. The term that we often use again about for-profit and non-profit. Lots of people still have a lot of misinformation in regard to what is a non-profit and what is a for-profit. A not-for-profit doesn't mean that you make no profits. It's one of the myths that people carry that, you know, I should never have surpluses. If I have surpluses, I will be in a big problem. I mean, I must constantly show loss, or I must have a no profit, nothing could be further from the truth. In fact, if you look at the definition of Section 8 under the Indian Companies Act, the clear definition of what is a not-for-profit is found over there. It talks about any surplus that is generated is not given by way of dividends to its members or shareholders or board members. What happens is that any profit that is made or any surplus is plowed back within the organization to further its aims and objects. So that's the real essence of what is a non-profit. And again, another term that people use interchangeably, I'm tax exempt, sometimes they say I'm tax free, and we are more focused on that ATG rather than a more important thing, which is 12AB. There are two things. There is tax exemption and there is tax deduction. Tax exemption means you as an organization, whether a trust society or a Section 8 company, is exempt from paying any tax. Whether you're a trust society or a Section 8 company, if you have a registration under 12AB and which has been renewed, your income is exempt from that. And the term tax deduction is a deduction that you give to your donors. When donors give it to you, they get a tax deduction in computing their income, which is liable for tax. So with that, we come now to the next slide. Can we have the next slide, please? The next after this. It's basically to understand the key differences between trust, society, and a company. When I refer to company over here, I'm referring to a Section 8 company. So first of all, please understand that there is no such thing as a Section 8 company also. A Section 8 company is either incorporated as a private company or a public company, but is licensed under a provision of the Indian Companies Act 2013 called Section 8. Under the old Indian Companies Act of 1956, it used to be called Section 25. Now it is referred to as Section 8. So you'll see three columns over here. The first column is with regard to trust. The second is with regard to society. And the third is regard to company, which is Section 8 company. What is the Registration Act? Now, if you are a trust and you happen to be in certain states like Maharashtra, Gujarat, Rajasthan, Madhya Pradesh, there is actually a registration, a state level registration trust act in place. For example, Maharashtra has the Maharashtra Public Trust Act. Gujarat has its own act, Madhya Pradesh. But there are a lot of states that don't have. In fact, you must have read in the newspapers a few days ago that the government of India is making an initiative to actually have a trust act in place for states that do not have a trust act in force and put in the office of the charity commissioner. So a lot of trusts which are right now existing in states like even Haryana or UP, etc., where there is no state level trust act in force, what they do is they just create a trust deed and register it with the sub-registrar's office. And after that, seek tax exemption, tax deduction. And because there is no state level charity commissioner or a state level trust act in force, many seem to be under the misnomer that there is always the Indian Trust Act of 1882. The Indian Trust Act of 1882 applies to private trusts and not to public charitable trusts. So the Registration Act, if you right now happen to be in states like Maharashtra, Gujarat, Rajasthan, and Madhya Pradesh, you would be under the state act of that particular state. Where society is concerned, we have an All India Societies Registration Act of 1860, but every state has got its own modification. So Societies Registration Act, as applicable in the state of Maharashtra, is not necessarily in sync with what it may be in a state like Karnataka, or especially in the Northeast, where societies are required to have renewals every year, etc. So each state has adopted, or rather adapted, the Central Societies Registration Act of 1860 to its state's requirement. Of course, the Registration Act for a Section 8 company is the Indian Companies Act right now of 2013, where you incorporate yourself either as a private company or a public company, and then you seek license under Section 8 to be a not-for-profit organization. Who's the regulating authority? In states where there is a charity commissioner, the charity commissioner regulates you. But there are lots of states in in India, where there is no charity commissioner. So if you have just registered your trust deed, then probably the only regulator you have is the income tax, who regulates you for tax exemption, tax deduction. If you are registered under FCRA, probably the Ministry of Home Affairs also regulates you. But at the state level, several states in India do not have a trust act in force or an office of the charity commissioner, but efforts are being made now to ensure that every state will have it. So that's coming. We've seen that in the newspaper only a few days ago. So who's the regulating authority for society? It's usually the registrar of societies, and for a company, it is the registrar of companies. The name approval process for the trust. In most states, I've observed that there is no process laid down by the state authority, and therefore you find several organizations with the same name. You know, ABC Trust, and there is an ABC Trust in Mumbai, and there is also an ABC Trust in Pune, and there is another. And because the process of name approval doesn't happen in trust and societies, in certain states, they have a mechanism, but I found in many states there is not there. But under the Companies Act, the first process before you want to register your company under Section 8 is the name approval, because they want to see that there is no other company registered by the name already. But having said that, you may register your name under company, but there may be a trust by your name. So ultimately, if you want to safeguard your name, of course, there is always the route of trademark that you can take, where you trademark your name, etc. But we don't want to get into those technicalities right now. Now, the important part, who is the board in a trust? You refer to the governing board members of a trust as board of trustees. In a society, you call yourselves managing committee members of your society's committee or an executive committee. In a company, you call yourselves the governing board of directors. So the governing board in a trust is trustees. In a society, it's usually called the governing committee or the governing council or managing committee. In a company, it's the board of directors. Now, what's the minimum requirement of a board? In Maharashtra state, the charity commissioner insists that you should have a minimum of 3. There is no upper limit really put. For society, what happens is the law requires that you need 7 members to start a society. And by default, the 7 members who form the society become the first managing committee. So many usually have their governing board of 7 people, because the 7 members who create the society also become 7 members of the first managing committee, and so on and so forth. So almost forever, people try to keep 7 members on their managing committee. The law doesn't say that the minimum number of your board members should be 7, but it's a kind of an inference that people derive. Where your board of directors is concerned, for a Section 8 company, if you are incorporated as a private company, then you need just minimum 2 directors. But if you are incorporated as a public company licensed under Section 8, you will need at least 3 directors. Number of members to start in a trust, there is no concept of membership. So, I mean, there are no members. But in a society, you'll need 7 members who by default become your first managing committee. In a company, you require minimum 3 members if you are a private company, incorporated as a private company. But if you are public, then you need minimum 7. That's a requirement under law. Next slide, please. Can we have the next slide? Yeah. Now, if you will see where income tax is concerned, FCRA is concerned, and your commercial activities is concerned, whether you're a trust, whether you're a society, whether you're a company under license under Section 8, the income tax gives you equal treatment. There is no preferential treatment that you will get as a trust or a society or a section. That you'll go through the same process of getting your exemption under 12AB and the ATG. It doesn't mean you're a company, so you'll get some preferential treatment, or if you're a society, you'll get income tax treats you equally. Ditto for FCRA. FCRA doesn't give you preferential treatment if you're a trust versus a society versus a company. You'll go through the same rigor, regardless of whether you're a trust, society, or a Section 8 company. Now, the commercial activities, which is business-related activities, and Anil will probably elaborate a little bit more on that probably. Many of us may have fee-based related activities, which are considered as revenue-generating activities. Now, there may be products made by your beneficiary. Many people think that if I want to sell products, if I want to provide services, I think I should go as a Section 8 company. The answer is Section 8 company doesn't give you any particular cover. Whether you are a trust, society, or a Section 8 company, it's the income tax law which governs your commercial activities. And the income tax requires that any kind of business activity that you have, A, must be in furtherance of your objects, and B, if you happen to fall under the category called any other object of general public utility, GPU as we call it for short, then in that case, your commercial income, your business income should not be more than 20% of your non-business income. Of course, there have been last year some Supreme Court judgments also in that regard, which is, in my opinion, it's quite favorable, but I don't want to discuss in the technicalities of compliance right here. Maybe during interaction, or Anil will cover that. Let's have the next slide, please. Where GST is concerned, many people tend to think that trust societies, Section 8 companies, we are charitable in nature, so GST is exempt. Answer is no. The GST law is very clear. It says that organizations registered under 12AA, now it is called 12AB, are exempt from GST, but having certain activities. Now, this means that, please understand that Income Tax Act and GST are two separate pieces of legislation. Income tax is a direct tax. GST is an indirect tax. Indirect tax meaning the consumer of goods or service pays the tax, not the producer of goods or giver of service. So it's an indirect tax, as we call it. And NGOs are not specifically, only a certain categories of NGOs working with the mentally disabled, etc. So there are certain activities that are exempt under GST, or even otherwise. You can't say I'm an NGO, therefore I will not pay GST. Let us say you buy a computer. You can't go around waving a flag that I'm an NGO, so please don't charge me GST. The person who will sell you a computer or sell you a car if you need a vehicle for your work, etc., GST will apply. And you can't wave your NGO card saying, hey, I'm an NGO, I exist for charitable purpose, don't charge me GST. So GST works both ways. You will charge GST for any goods or service that you will acquire or want to buy. And even you, if you become a service provider where the supply of your service exceeds more than 20 lakhs in a given year, or your goods, supply of goods exceeds 40 lakhs in a year, you will have to register under GST as an NGO and charge GST to the consumer of your products and service. That means it's not a financial burden on you, but it becomes a compliance burden on you. That's the idea about GST, which I will touch. Labor laws. You cannot say I'm a trust society or a Section 8 company, so I will not pay provident fund to my employees. It will apply to you. If you have more than 20 employees, EPF is mandatory. You have more than 10 employees, gratuity will become mandatory. And a whole bunch of HR laws, which we are not touching upon today, are actually mandated for you. Board liability. Now, this is an important one for you to understand from a governance point of view, that only in a Section 8 company, the liability of the board members is limited to the share capital of the company or to what we call as limited by guarantee. In a trust or society, the liability of the board of trustees or managing committee, as we like to call it, can be personal. So in case of any outstandings, etc., which the trust is unable to give, the direction can be given by the regulator for the trustees to pay up. So, I mean, it exposes you to a little bit of liability, and it's one of the most plus points why more and more people are now inclined towards going in for Section 8 company to protect against personal liability for the trustees. Power, where does the power in a trust vest? It's in the board of trustees because there's no concept of members. But in a society, the real power vests in the members of the general body, the AGM as we call it, the annual general body meeting, where members are given an account of performance. The audited accounts have to be passed by at the AGM, appointment of auditor, and any change you might want to make in your constitution, which is your memorandum and rules. It is the general body that has the powers to do that and not the managing committee. Ditto in a company, it would be controlled by the shareholders or the members of the company. Board rotation, usually in a trust, unless you have given a provision for rotating your trustees are deemed to be for life. But in a society, you would have periodic elections. In a company also, you would need to have rotating of your directors, etc. Do you need to have an AGM in a trust? You don't, because there are no members. You don't need an annual general meeting. But in a society, you would require. In a company also, you would require. Members in a trust, there is no concept of having members. There are only trustees who are accountable to each other, joint and several responsibility, etc. In a society, there are members. In a company also, you have members, or you might have shareholders. Remunerating your board members, again, the income tax gives equal treatment. Trust, society, or a Section 8 company. If you wish to remunerate your governing board members, A, there must be an enabling provision in your constitution, which means your trust deed or the memorandum and articles of association. And B, it must meet the test of reasonableness, that any remuneration that you give must be a reasonable remuneration. More on that when we have the interactive session. Next slide, please. So now we come to the part which is having made the comparison between trust, society, and Section 8 company. What really is good board governance? Good governance is a transparent decision-making process in which the leadership of the organization, when we talk of leadership, it starts with the board, moves on to the CEO, COO, CFO, and the rest of the team in an effective and accountable way, and directs resources. The term here again is use resources. This includes financial resources, intellectual resources, human resources, and exercises power on the basis of shared value. This is one of the finest definitions, or I would say explanation of what good governance is, that has been devised in one of the NGO related workshops that I was part of about some 15-20 years ago. Let's have the next slide, please. So governing board in an NPO, in a trust, as we already saw, is board of trustees. In a society, it will be either called the managing committee or the governing council, and it will be board of directors in the case of a, earlier it used to be called Section 25, now it is called Section 8 company. Next slide, please. What is the role of a board? Now, again, when I speak of the board, I'm using the generic term governing board, whether it's a trust, society, or a Section 8 company. Funds, properties, assets of the organization legally vest in the governing board. Legally vest meaning it almost as if it belongs to the members who are the governing board, but it is held in a fiduciary capacity. That means they must hold it for the purposes that have been stated, A, in the trust deed or the memorandum and articles of association in case of a company or a society. That is, the fiduciary capacity means they have to do it as directed by the settlers of the trust or as provided in the constitution. So it's a very fiduciary duty that board members have. Be acquainted with and advance and further the objects. It's most important. I've seen n number of board members who often come with issues, but when I tell them, have you ever had a chance to look at your trust deed, or have you ever seen your constitution, the memorandum and articles of association? 9 out of 10 times, I'm afraid, they didn't even know that a document like that existed. So they say, yeah, it's somewhere probably in some file, etc. It's the most important thing. Every board member needs to know what is the aim and object of your organization, whether you are a trust, society, Section 8 company, and operate the organization within the framework of the organization's own charter, By charter, I mean the trust deed or memorandum and articles of association, whichever the case may be, depending on what is your structure, and the statutes governing the organization. And there can be multiple statutes. Anil will be talking about that. At the most basic, at the state level, it may be the Societies Act, Trust Act, Income Tax Act, FCR, and a host of other allied laws as well. There are too many to enumerate today. Next slide, please. Board members should not derive any personal benefit from the organization. This is one of the key understandings that you are there in a fiduciary role, and you are not there for your personal benefit, or even, in fact, Income Tax Section 13 is very clear in this regard, that if any personal benefit is derived by any board member or even a relative of the board member, and relative has been defined under the Income Tax Act, it could jeopardize your tax exempt status. And in that year, there could be certain tax liabilities for your organization, regardless of whether you're a trust society or a Section 8 company. The other thing is joint and several responsibility, especially in a trust. All trustees are jointly and severally responsible. The concept of what we call managing trustee is unknown to law. Many people say, I'm a managing trustee. The law doesn't define who is a managing trustee. The entire Trust Act is silent in terms of managing trustee. There is a concept of a managing director under the Companies Act, but there is no concept. So everybody is joint and several in a trust. As board members, you need to oversee financial accountability, transparency, and sustainability. I'm not saying that you have to be looking at the books of accounts all the time, but you have to exercise due diligence and ensure that books of accounts are maintained. In fact, keeping books of accounts is mandated under the Income Tax Act. Especially last year, the Income Tax has even defined for us what are books of accounts and what are the records you need to keep and for how many number of years, etc. It's all very clear now under the Income Tax. What is books of accounts and what is the period of time to keep it? You need to set policy through process of periodic review, meetings, and resolution. What does this mean? Policy of the organization. What is our policy on fundraising? What is our policy on POSH, for example, prevention of sexual harassment at the workplace? What is our procurement policy? There are a whole bunch of policies, and this policy requirement is of the role of the board. The CEO may inspire the board to do this, but ultimately it's the board's responsibility to formulate and drive policy of the organization. This is what we will do. This is what we will not do. So the value system of the organization, policy, etc., these are all board responsibilities. Next slide, please. The role of the board in general is to provide leadership and vision. Many a time people think, what really does the board do? The organization is CEO driven. I think that's such a big mistake. You know, any organization that is only board driven or only CEO driven is a disaster. It has to be a combination of both. Leadership and vision has to be provided by both the CEO and the board. And I will talk to you about the governance structure with vis-a-vis board and the CEO as well in a little while. Give the organization a clear sense of direction. In what direction are we heading? Set policy. It's a very important job role of the board members, and take responsibilities in good times and in bad times. We often find that board loves to take responsibility for all the good that happens, but when anything goes wrong, blame it on the CEO. That's not the way to do it also. If something goes wrong, stand by your CEO and support your CEO. Take that responsibility as a board, because the board's role is to govern, hold the organization together. Next slide, please. Mobilize resources, a very important role of the board. Many years ago, some 20 odd years ago, when I joined an international board, it happened to be an American board, and there was the first day orientation and welcome to the board, and some nice things were said. And towards the end, they said, I wonder if you guys are even aware, the new board, about the principle of the 3 Gs. Here I've written about the 3 Ts. The Gs have become T now. The principle of the 3 Gs 20 years ago was give, get, or get off. Give to the organization, get it if you can't. They were mainly referring to funds, or get off the board. Of course, now they have watered it down to the 3 Ts, where you give your time, talent, and treasure, which is you give of your time to the organization, you give of your talent, which you have, and treasure meaning the treasure of your network, the treasure of your wealth, etc. and the 3Gs have become 3 trees. So I've seen a little bit of the transition happening, at least in the United States. Build and nurture an ethical, sensitive, motivated, and responsible team. Discourage exaggerated or misleading claims. This is where the check and balance is done by the board. The CEO and the team would like to create a wonderful story, and the board may say, is this all valid? And the board has this check and balance that comes across where, because the board has no financial kind of stake in the whole thing, whereas the CEO has to show progress. CEO gets a salary, the team gets a salary, and they have to show performance. But the performance checks and balance can be done by a board that is a non-remunerated board. So the check and balance comes through the board. Next slide, please. Meetings, a very important function of the board. How often should a board meet? Sometimes your constitution tells you that meet at least 4 times a year, that is meet every quarter. Many a time the trust lead is silent. Unfortunately, even the laws are silent in this regard, except in the case of the Indian Companies Act, where quarterly meetings by companies is mandatory. But there also Section 8 companies have been given some liberty that you need to have at least 2 board meetings in a year, plus 1 AGM. But otherwise, if you're not a Section 8 company, then every quarter the board has to meet. But in a trust or society, nothing has been stated under law. So trustees feel we will meet only as often as required, or maybe once a year. It's not a good idea. I would think that if you can meet at least every quarter, it's a great thing. At least try to meet 2-3 times a year. But AGM and EGMs, of course, they are required if you're a society or a Section 8 company. The requirement of an AGM or an EGM is not necessary in a trust because you have only trustees, you do not have members. What is your board agenda? Half the time, the board agenda is so boring that nobody likes to go for the meeting. So, I mean, you need to make the agenda such that you feel enthused enough to go for a meeting and say, hey, I think I can contribute on this topic. It may be with regard to a strategic plan. It may be with regard to reviewing the progress or a whole bunch of interesting things. But if you will say the board is simply meeting, and that's, of course, a statutory requirement to appoint the auditor or to appoint the CEO or, to pass the accounts. I mean, the accounts can be sent in advance and people will just say, yeah, the accounts look fine. Let's get on. I mean, no need for me to come. I'm approving it. Let your agenda be a little interesting. Resolution by circular, yes, permitted under law. Validity of video conferencing, yes, under COVID times, there was a relaxation, no need to meet. And that has actually been a trendsetter that you could even consider video conferencing, provided you at least record these meetings. Although with regard to financial matters, etc., Companies Act still requires, although there was again relaxation during COVID times on that there should be physical versus virtual meetings. Writing and maintaining minutes, very important. Minutes is a record of what you discussed and decided upon. And for a lot of things in life, you will need resolutions. Simple things like opening a bank account, having FDs, making investments, resolutions will be asked for. So resolutions are important and they must be recorded in a register, which is to be called the minutes book. There is a method for doing that. Just touching upon those aspects of meeting. Next slide, please. Board meetings. Good meetings are a key to good decision making, and it is often at the meeting table that the quality of the organization and its leaders is truly revealed. It's one of my observations that I'm making here. Next slide. Good board should have interest in the work of the organization, have commitment to the organization's aims and objects, have reasonable knowledge and competence. By that, I mean knowledge about the field of work that the NGO is involved in. Also, most importantly, knowledge of statutory requirements. At least a working knowledge of what are the compliance requirements under the Trust Act or Income Tax or FCRA. Board members need to be knowledgeable about that. And of course, they can have various other competencies, etc. They should be respected in the community and by all stakeholders. Next slide, please. Have capacity for growth, on the board. Sensitive to change and tackle new issues affecting the community. Ability to work in concert with others, stand up to one's conviction, treat stakeholders as partners, and the ability to take a stand. Yeah, I'm just running through it because I know that time is running short. So next slide, please. Good board should respect the right of other board members and CEO to differ and disagree. It's one of the things that I notice on boards, that disagreement is good. Disagreement is actually healthy. But let's disagree, but let's disagree in an agreeable manner. Dissent if necessary, but accept with grace the majority decision, or if you feel too caught up about it, you can always step down and effectively mobilize and properly channel resources of the organized. Again, I'm using the term resources, which includes human, intellectual, and financial resources. Next slide, please. The concept of govern versus manage. Boards must learn to govern, that is macro manage, versus manage, which is micromanagement, which is the work of the CEO, the COO, CFO, and the rest of the team in the organization. The board's role is to set the strategy, the policy, and then leave implementation of the strategy, policy, and the day-to-day affairs in the hands of the CEO, COO, CFO, and the teams that are under it. Next slide, please. Governance is mainly linked to accountability and transparency, self-regulation, and organization sustainability. I cannot more than emphasize this point that yes, I mean, to ensure that the organization is accountable and remains transparent, that policy is to be set by the board. Self-regulation, doing more than what even the law requires to do, and ensuring the organization's sustainability from a human, financial, and intellectual perspective. Next slide, please. How boards can improve. Now, here is an interesting bit. We always like to evaluate the CEO, the CFO, and the staff. But how about evaluating yourself as a board member? I have been on international boards and I know it, that every board member on an international board, at least the ones that I've served on, we go through a process of self-evaluation where we check what has been a contribution to the organization. In India, unfortunately, the board only loves to evaluate the staff, but doesn't do any self. So we have a lot of deadwood sometimes on the board. Sorry for that term, but quote unquote, that's it. I mean, they are just on the board without any kind of contribution. Boards can improve by having a very clear strategic plan for themselves and the organization, establishing systems of check and balance with the CEO and the staff. And how do you manage non-contributing members? This is a matter for debate. I mean, during the interaction, we may or may not talk about it, but this is a perennial issue with the organization. I have one or two members who hardly come for the meeting, who are doing just nothing. What do I do? How do I manage them? It's not something that I want to preach on. Maybe if time permitting, we may discuss. Next slide, please. So how boards can further improve system of rotation. One finds that there are sometimes board members for the last 20 years, nothing. I mean, they just refuse to vacate. Do have a sense of rotation, agreeing on the organization's mission, focusing mainly on what matters. Half the time, the board loves to discuss matters that are hardly of consequence to the organization and forgetting what really matters. Other important thing, knowing specifically their role as board members. What happens in India? Somebody's taken on the board. You say, yeah, this is a good organization. I think it'll look good on my CV. I'm going to join it. Would you ever have a staff member? Would you ever appoint a CEO or a CFO or even a ordinary clerical person in your organization without a clear job description? You will have a job description, what you're supposed to do. 9 out of 10 times the board member is appointed, but the board member is clueless what is his job description. What am I supposed to do on the board? You are simply given an appointment letter. Hey, join. He's my friend, so I've put him on the board. Not the way to go ahead. Function as a team. Of course, I cannot stop emphasizing on that. Next slide, please. Priya, I'll take another 5 minutes because I started at 4.5 and surely in the next 5 minutes, I will close. Good board qualities, stimulate rather than browbeat members of the team. Start and end every analysis and evaluation with the standard benchmark. Is this right? I have often been on boards where complex issues are discussed. The issue, there is only one benchmark. Now I find on board sometimes it happens. Oh, but if I say this, the chairperson will get upset with what I'm taking. So I must take a stand which is, the chairperson will be very comfortable with. You have to, the only benchmark for decision making is it right? Now again, what is right and wrong is a matter of perspective. What is right to you may be wrong to someone else. The point is it morally right? Is it right from the perspective of the organization? Will it harm the organization or will this decision be good for the organization? So you as a board, and board position is all about decision making. You are a decision maker, and your decisions will either make the organization, and I've often seen it even break organizations on matters of policy. Fairness, of course, the most important quality a board member should have. Next slide, please. Flexibility, except on matters of core principles and values. Board members should keep that flexible mindset, open to new ideas, and of course, be an enthusiastic board member. Nothing was ever accomplished without enthusiasm, is a very famous saying by Emerson. Next slide, please. Key areas for board responsibilities towards the mission of the organization. Ensure that the organization remains on track with its mission. Oversight on finance, performance, etc. That is, constantly oversee that things are being done right. You don't have to micromanage, but macro-manage in terms of oversight. Resources, yes, I can't stop emphasizing. Ensure human, intellectual, and financial resource for the organization. If you can't give yourself open networks for your CEO, etc. And of course, the outreach. Every board member needs to be a good ambassador of the organization. Next slide, please. Role of the CEO. I'm not going to elaborate on this. Skip this, please. Go next. This is the organizational structure that I want to speak about. This is what is often known as the governance pyramid. At the apex of the pyramid, the top of the pyramid, is the governing board. The role of the governing board is to set policy, strategy, and give vision. In the middle sits the CEO. It's the governing board that hires and can even fire the CEO. In the correct terms of good governance, the CEO then hires and fires the staff. It's not the board's role to hire and fire the staff. In India, the board appoints even the peon. I have seen that also happening, and which is not a good practice. The governing board sets policy, strategy. The CEO implements policy, strategy, vision of the board through the staff which is hired and can be fired by him. And that really is the governance structure. And with barely 2 minutes to go, I do not want to do injustice to Anil and eat into his time. So keeping the discipline, I'll stop at this point, Priya. And I would request Anil to take over from this point, and I will sit back to listen to him. Thank you very much for your patience, everybody. Thank you.
Thank you so much, Naushir. Like I said, we're going to be proceeding with Anil first, and at the end, we'll have a combined Q&A. I'll ask a few already given questions first, and then anyone can unmute and ask, but that will keep for 20-25 minutes at the end. We're trying to keep as many minutes as we can at the end for the interactive Q&A, but not to take in any more time, I'll pass over to Anil, who will be covering certain compliances that NGOs need to follow in terms of financial and even tax. And once Anil is done, we'll quickly move to Q&A. Thank you.
Thank you, Priya, and thank you, Naushir. Naushir has given a very detailed and nice way of understanding the various structures of NGO, or we call it voluntary organizations or CBO, and how they can, in a transparent way, can conduct the activity of NGO so that it runs smoothly. What is the object of any NGO? It's an NGO is anything goes with peace of mind. And the peace of mind comes with only two aspects. You are doing the right thing with the right attitude and in the right way with right compliances. All the broad principles of various acts are always written in a very cumbersome and technical languages, not easy to understand. So hence, this presentation is going to bring you the various compliances which is required under various acts in a very simplified manner so that you can understand what is required, what is not required. And I would request if, Priya, my presentation can be put as a first page. So this is primarily is for various compliances for charitable entity, whether it's a trust, whether society, whether Section 8 company. When you say any charitable entity, wherever created in the country, the laws remains the same, barring the Trust Act, which is specific to a Maharashtra Act. Otherwise, rest all the acts are common to all entities, whether it's a trust, society, and company. May I request for the next, please? If you can move to the next, please. It's just an index. Yeah, so first we are covering the various things which is under the Income Tax Act, because ultimately you are questioned by income tax people whether you are doing a charitable activity or not. Hence, the clarity should be in your mind that once you are registered, you have a 12A, ATG or whatever, what tests you should comply in that part. Next slide, please. As Naushir has also mentioned, that the Act has not specified religious, but a charitable activity. And how do you prove you are a charity? To prove that you are a charity, you first need to apply to the tax office, and the tax office then issues you a certificate that they recognize you as a charitable entity. So whether it's a trust, society, or a company, they need to apply under section 12AB, which is more technical as a section, but we don't need to remember the sections. We need to apply to the Income Tax Act online process now. It is not an offline process. Earlier, the section 12AB registration used to be once in a lifetime. Once you get the charity registration done, then it is not questioned for the entire life cycle of the trust or entity, which is for which it is registered. But gradually, I think the government realized or tax officer realized that we need to review the activities of the entity. Hence, they made it now, every entity needs to re-register every 5 years. It was done a couple of years back, but now the process is more simplified. You again apply online, and once you apply online, within a period of 6 months, by default, they issue you a certificate online itself. Once you get this certificate, whether temporary, whether permanent, it entitles you to claim benefits of a charitable status and the expenses, non-taxation, exemption, whatever is applicable to a charitable organization. Next, please. The language more here is we will circulate or upload later on for the clarity, but I'm trying to cover the gist which makes it very clear to you. What do you require? Once you have become a charitable organization by taking a 12A certificate, you can do charitable activity. Now you can claim exemptions, you can do the needful, and you can spend more than 85%, and corpus can be built from the remaining 15%. But if you want that your funding should be more and more coming from the donors who really normally want that whether they will get the benefit of donation, for that you need to get another registration which is called ATG registration. You can apply only after you are registered along with 12AB or thereafter separately. And again, it's a back-to-back as a charity registration. Once you get this registration, it means any donor to you gets a 50% rebate in their taxable income when they donate it. So you should be very clear. ATG registration is not mandatory to be a charity. It's a registration to give benefit to the donor. If you want to be a charity where the donation benefit is not to be passed on, or you have not been given ATG, it does not deter you to do the charitable activity because you are still a charitable organization. You can do the charity. Only thing is that some donors who are very particular, who wants to claim the benefit of ATG benefit in their taxation, they may hesitate to give you the donation. But if they really want to give something back to the society, they may still give you the donation and you can still do the charitable activity. Next slide, please. From the compliance point of view, you can go to the next slide, please. From the compliance point of view, you being a charitable entity, now an additional requirement was made where how do the donor gets to know that you have been given the donation and you have uploaded the details on online process of tax department. So tax department is gradually trying to collect the information of donors, who is giving, how much is he giving, what is a PAN number, and in the near future, I'm sure this information will also be available into your 26AS, like any other TDS. As of now, it is not available, but gradually you are supposed to file this information online for all the donations. Only thing is, the government or the tax department as of now does not require you to file everything in one time. You can file as many forms as is possible, covering the entire donors list. The last date is 31st May, which is 2 months from the end of the year. And there is a penalty if you don't file it. So hence, you should be very, very particular that your complete donation should be covered by filing Form 10BE online, and 10BD is successfully filed and 10B is generated, which needs to be given to the respective donor for their records. This is a requirement which came last year, and it was the first time that it has not been practically implemented and no penalties have been put so far. But it should not be taken as a lightly, and one should not take it from the point that if the donorship received, it should be filed within time. There is no process as of now to correct it correctly. So hence, if you make a mistake, you might have to put both the things, but you can still do it. Now the opportunities have come where you can amend and do the corrections for the PAN number, address, name. Sometimes mismatch can happen. Next slide, please. This is very relevant and very important for you all to know. We all know that the donor commits us to pay the money, or any CSR companies commits us to pay the money, but that money is not released to us, or they have given the condition that this money which we are giving it to you is going to be spent from May next year to December next year, even though the money has been received in the month of March. In such cases, your accounts will reflect the collection of the money, but it will not show that the money has been spent, because that money can never be spent as per the condition of that. So the Income Tax Act defines to file a Form 9A, which normally is not very much aware in the practice of an NGO, that they are supposed to file a Form 9A for those monies which has not been received in the previous year for some technical reason, for some contractual reason, for some any statutory reason. Suppose there is a litigation and court case, and court puts a direction that you cannot spend this money. Now what to do? You have a reason not to spend money. But in such cases, or there is arbitration going on, anything which is a dispute or statutory requirement, NGO is supposed to file a Form 9A, putting it in effect that this money is in our bank account and it will be spent when the things will be over, and it will not apply for the purpose of 85% spent of that year for the calculation purposes. Next slide, please. Earlier 9A was for the things which is not in your control. Form 10 is important for all the NGOs to ensure that they were supposed to spend 85% of your collection, earning, donation, everything. If you fail to spend 85%, then what happens? Either you pay tax because you have spent less than 85%, or you can file a Form 10, carrying it forward to the next year. As per the law, you can be carried for the next 5 years. But then you have to file a Form 10, which is seeking an exemption to spend in the last year, not exemption, rather taking a permission to spend in the future year. And that purpose is taxation department knows that this money has been carried forward to the next year. So the next year, you will spend the 85% of the respective year, plus the carried forward amount also. And if you do not spend in the next year, then automatically, at some point, unspent money below the 85% would need to be taxed as per the applicable sections that will be there. The same, this presentation shows an audit report. It's in compliance that every charitable organization who has been given a 12A registration needs to file an audit report, which audit report is given by a chartered accountant in practice. and that audit report is filed online 1 month before the due date of filing the return. Currently, due date for the audit report is 30th September. And then once you file the audit report before 30th September, then tax return can be filed before 30 days thereof, which is 31st October. Mind, I'm telling you all these provisions because non-compliance of these can result into cancellation of your charitable status. Hence, this should be taken very seriously, very diligently, and by a proper understanding. Because human error is something which is different, but error of a judgment or error of not understanding the provision of law, which keeps on changing, will not be considered as an ignorance of law, is not an excuse for anything. Next slide, please. The NGOs who are educational institutions, they have to file their audit report in the 10BB instead of 10B. It's just that kind of a change. So it depends on the activity of the NGO, what kind of this thing. Only for educational institutions, the format has been changed. Instead of 10B, it is 10BB. ITR Form 7 is the form which is there for the purpose of filing of return. Now, all these forms nowadays are to be filled online, and they are fairly technical. It's not an easy affair to fill correctly by own affairs. So I presume most of the NGOs, rather 100% of NGOs, take the assistance of the chartered accountants in this, so that there is no error of filling the form, because nowadays corrections or updated returns are a cumbersome process that should be avoided. Next slide, please. So far, we have just understood the tax-related compliance, which are very, very important because they affect your charitable status. Now we are coming to the other acts, which does not affect your charitable status, but which needs to be complied. First, such main important act is indirect tax of GST, which is goods and service tax. And there are many issues which we are ignorant. Otherwise, I will try to cover up as a layman so that you know in a normal compliance of an NGO, what sort of a GST compliances or applicability comes. It is not an exemption given to any charitable organization, as Naushir has already clarified, whether trust, whether society, whether company, GST, if applicable, is applicable. There is no exemption. Next slide, please. GST is applicable across the board, as here. We have to see that what activities will be entitlement. Right now, the threshold of GST is turnover sale of above 40 lakhs. If your sale above 40 lakhs is there, then GST may be applicable on your turnover also. But for that purpose, there will be one relevant section whether I'm doing a commercial activity or not. That's a separate from the point of view of income tax. But GST does not consider that charitable activity or commercial activity independently. Hence, if you are selling a products, even if made by your own beneficiaries, like we all know, Diwali Mela in Delhi is the most popular by blind school, which does it for 9-10 days. And the stalls are given on the hiring and everything is there. Even though it's applicability back to the blind school purposes, that might be a separate income tax application, whether it's a commercial activity or not. But so far as the GST is concerned, GST is applicable. I give an example just to clarify that if my taxable turnover is above 40 lakhs, then my GST is applicable for registration purposes. For registration purposes. Whether I register or not is again should not be defaulted, because there are penalties involved onto the governing body of the entity or directors of the entity. It is on applicability on the taxable revenue. Whatever you pay to take the services or goods, that in any case you pay the GST, because the other party who is providing the services or you are selling you the goods is not exempt, so he charges you. Next slide, please. Here It's to cover that what is charitable activity from the commercial aspect of it. Now, Section 2, subsection 15 of Income Tax Act defines the charitable activity, which is very, very specific, which is mainly covering healthcare, which is defined in a certain language as above, as given in this, or advancement of any religion, where earlier the yoga was not a part, now the yoga is added a part a few years back, advancement of educational programs, and preservation of environment. Now they have said these are considered as a charitable activity. So any activity which is for advancement of these, and you do any sale or transaction or commercial, any activity for that to earn revenue, will not be a commercial activity for income tax. Which means when the income tax says a commercial activity is allowed up to 20% of your total collection, total revenue, above sale will not be treated as a commercial activity, and that will be not a part of the 20%. Even though you are charging GST on it, even though you are doing other related compliances of other act, but Income Tax Act will treat this as non-commercial activity so long as it is falling under Section 2, subsection 15 of the Income Tax Act. If you are not falling within this act, this definition, then those will fall as a commercial activity. Commercial activity limit is 20% of your total collection, revenue, sales, whatever you call it. And if your turnover goes beyond 20%, the tax officer might give you a notice by hearing you a personal appearance, or otherwise they can treat you as non-charitable and they can cancel your charitable activity license also. Some of the skill development councils who were giving the skill development certificates were counted originally as non-charitable and their certificates were cancelled. But through a court interference or otherwise, it was brought to that skill development is a part of educational program. And it should not be considered as a charitable, non-charitable, or as a commercial. Hence, you should not try where the things can be give you a peace of mind simply than to try something where the income tax gives you a notice and you have to prove something else. Next slide, please. So GST, I have already clarified that GST compliance is required if your sales is above 40 lakhs. How the compliance will take place is again an operational issue. So I'm not covering that part because most of the NGOs do not normally try to go into the sales and other kind of a consulting services which goes beyond 40 lakhs, making them GST compliance to be made. Next main relevant act which everybody is trying to know is FCRA compliance. You can just change the slide, please. Now, in this, one foremost thing which I want to bring to everybody's attention is where does the FCRA application applies? We all know that any money coming from foreigners, from overseas, in foreign exchange, FCRA should be there. For your clarity, sometimes we forget about it should come from a foreigner. If it is coming in foreign exchange, but an Indian passport holder, it is not FCRA. You can still take it with no application of FCRA. So even though it's not written in my presentation, I just want to clarify to all of you, Indian passport holder, wherever situated in the world, can remit the money in foreign exchange to your trust, society, company, and that will be accounted for as a non-FCRA fund. You don't require a compliance of FCRA. So FCRA is only for when your contribution is coming in foreign exchange from a foreigner. Hence, this distinction, if clear in your mind, can help you sometimes because your non-FCRA fund is not going to FCRA and you have a better control in a non-FCRA fund. FCRA registrations is, in any case, is a different compliance. It takes its own time. But in any case, it's like everything is online. very fairly transparent process. Obviously, Ministry of Home gives the clearance for all the office bearers, so it takes time for the office address, everything. So it's a process which is there. So I presume that we should go to the compliance part, which is more of that we have to file an annual return if you are FCRA registered. Otherwise, your next time returns application renewal will not be counted for that. And you have to file a quarterly return of all the collections in FCRA. These things are all online, but then these are sometimes in the main work of providing charity to the society, we forget to comply. Hence, from that purposes, we should make sure that annual return, whatever is due, whether it's a nil or whether it's anything, even then we have to file the return without taking a chance that whether it's applicable to us or not. But when you go for renewal otherwise, at that time, if you've not filed FC4 or the quarter returns, it may not accept you for the renewal filing itself. Next slide, please. All these things are various forms which needs to be complied. This FC6A, FC6B, FC6C, which we should normally tend to forget, because in today's world, if any entity changes the addresses within the same state for the reason of if they don't own the building, they're changing the premises because of the rental affair, or changes the objects, enlarging it or something like that part, or for some reason, somewhere it has happened that the bank branch has merged with other bank branch. Hence, the address has changed. By address change, automatically the bank account number has changed. So all those things, there is an obligation to comply within a deadline, which is normally a 15 days deadline. But normally, these things does not register in our mind that these things are also requiring any compliances, though it may happen once in 10 years, once in 5 years, once in 15 years. But if it is in our subconscious mind, it will immediately put us into alert that something might be required. Just Google it up or check with your client, check with your CA, check with your consultant, whoever you are relying upon. Hence, these things are very important to register. Sometimes, if your FCRA has been cancelled, please know that FCRA owned assets does not belong to the charitable entity. You can make use of the assets, but once your FCRA registration has gone, renewal has not been given, or whatever is not given, though there is no guidelines given, but then they belong as per the guidelines of central government in the manner prescribed. They might say, okay, give all these assets to so-and-so FCRA Research Society, NGO. Hence, you should not scrap your FCRA owned assets. Scrap in the sense, if it is scrap, keep it as is. So whenever it has to be, if there is a furniture, one leg is broken off the table, fine. But you should try to keep it, even though it's a pain. But you should know about it that it may be required someday. It's not a process driven where you can write off in the books is separate part, but write off physically is a separate part. So we normally say that keep all the assets at ₹1 to remind you as a fixed asset register that these were purchased from the FCRA. Next slide, please. CSR registration again came a couple of years back. Government wanted that NGOs at large should not be eligible to get the CSR fund. So they decided that all NGOs need to be registered with MCA and obtain a CSR2 certification. Once they get a CSR2 certification, then a CSR project needs to be given that CSR registration certificate, based on which the corporate can give you the CSR contribution. Now it's very interesting. A CSR compliant entity, a company gives you a CSR and you have not done a CSR registration. There is no penalty on the NGO. The only thing is that corporate cannot claim that amount paid to the entity as a part of the CSR. But obviously next time they will not give it to you, because in a way they have to contribute double, once to you and once to some other compliant CSR. But it does not mean that there is a penalty on you. It is always nice to have the CSR compliant certificate handy with all the particulars correct. One thing is very important in this is if your address changes, there is no provision in MCA right now to get the new CSR registration certificate with the new particulars. So once you are registered with the old particulars, it remains as historical. You need to then convince the corporate that this cannot change. It's a historical document. But you can obtain a new registration in the CSR. But sometimes there is a MCA is still not clear about it. And it's still an open question. But I'm clarifying to you from the point that you can tell the corporate that my CSR registration has a historical detail. I shifted from X to Y address from this so and so date. This is my new deed, and it will be applicable from that part. Next slide, please. So far, you can go to the next slide also. So far, we discussed about the main taxation, CSR, FCRA, GST, which everybody in general talks about. But what nobody talks about, because then everybody thinks that we have been exempted under the various other general compliances laws, which is primarily could be people related, your employer related, could be entity related, could be companies act compliances from the point of view of statutory registers related, could be IT safety policy or data security policy. All these policies, you may have the policies, but are they applicable to you? Nosher had given a very clear answer when he tabulated all the acts with trust, society, and company law, and a company under Section 15 or 25 or Section 8. Okay, that various acts are applicable as it is applicable to a commercial activity, company, or entity. Now, in any case, every NGO has employees working. Number of employees could be less than 10, more than 10, more than 20, depending on the scale of the operations of the NGO. In that case, all labor laws are applicable to them, especially NGOs try to pay less money to employees because they can get at a lower value. They have to ensure that the Minimum Wages Act of the respective state or offices where the office is situated is taken care of, because they are not exempted from the Minimum Wages Act, from the ESI, from the Provident Fund, from the gratuity, from the bonus, under anything. It's a perception that these acts are not applicable or exemption is there. Yes, these departments have a lenient view on the non-government organizations or an NPO because they feel the motive is non-profit. But that does not mean if tomorrow it's applicable, they will not charge you the money. And at that time, your unnecessary money which would have been used towards giving back to the society for the object is being going towards the compliance of these acts. Whether it's the ESI contribution of the person, Provident Fund contribution, minimum wage, lower than minimum wage paying, Payment of Wages Act that you have to pay by 7th or by the end of the month, depending on the number of people, Gratuity Act, Bonus Act, anything is applicable to you. If tomorrow you have a disgruntled employee and he files a complaint, then you have no legs to stand. Hence, this is most important aspect which gets ignored in our any NGO's day-to-day activity, unless NGO scale is too high, where these things are already taken care of. Second, the new aspects nowadays, IT policy, privacy policy, or data privacy, or whatever you may call it, that applies across the board of anything and everything. Any entity, any person who is having a database of another person, another entity, another thing, is supposed to keep it secret. It cannot make it so easily accessible or available to any other person, barring the hacker. Hacker can hack it, that's not your. So you have done a diligent, careful treatment to secure your data. Your data is what? Your data is on your computer. Your data is on maybe on the cloud. Your data could be anything. Your data could be which grantor has given you how much amount. Even this, everything is a data privacy IT policy. Again, currently, Indian government has not put a very much stress on any penal provisions going after it on NGOs or even the small organization for the IT policies. But then I wanted to clarify better, you know that it is applicable to you and everything has to be kept very transparent way. Your anti-piracy laws or any anti-viral software to protect any malware, anything to be given. Your people working should not use them just loosely on the phones, sending on the WhatsApp to everybody and anybody. All those things should be kept in mind. Coming to Shops and Establishment Act, again, registration under Shops and Establishment Act for any registration is a must. And you are an establishment. You can't say that I'm not an establishment. So this is required as per the state. Its respective state has a respective Shop and Establishment Act. One has to see that in the state where you are, what are the compliance issue. Again, this can be taken online nowadays. Only one exemption is there in Delhi state, which I can say in other states also I cannot say, is that a non-profit organization can work from a residential offices also, a residential houses also. Because government does not want them to spend more and more money into commercial areas which are more expensive. So they've given that exemption that yes, charitable organization can work from basements where the other officers are not allowed to work, from the ground floor, first floor, second floor, whatever, in any residential accommodation also. Coming to the Companies Act, which will be applicable only companies under Section 25, now Section 8. As Noshir has already very clearly said, governance, board of directors, AGMs, shareholders, if there is a shareholder, or is by guarantees, then guarantee, board of directors meetings, minutes, resolutions. These things are very important because what will happen is an entity works for life, while the same management may not last for 3 years, 5 years, 10 years. So how to see that all the documentation, judgments, decisions were taken at that time are properly reflected into action is these documentary support, whether it's a bound registers, minutes books, or soft copies. Hence, Companies Act is applicable and completely applicable in terms of liabilities, even though the liability is limited. But that liability is limited is only when one has to prove that he did not do carelessly, intentionally, or anything like that. All these compliance, if I can go to the next slide, please, if there is any, yes. Then I'll come. Yeah. Okay, this can be skipped. I can go to the next slide, please. This is a tabulation for the clarity. What sort of incomes or collections are exempt or taxable in the hands of a non-profit organizations. It gives voluntary contributions. Again, is subject to tax, means 85% you have to spend. Otherwise, it's an exempt category. If you get any anonymous donations, and anonymous donation is more than 5% of your donation received, or rupees 1 lakh, even though 5% is higher, but it is more than a lakh or lakh, then it is not exempt. It is not a part of 15%. NGO has to pay 30% tax flat. Normally, this is not in anybody's mind because this is exempted only in the religious part. Because in the religious hundis are there, people put the money into the hundis, and in the religious temples, gurudwaras, or anything of any religion which is there with respect to each of them, the money, people do not want to give the money with the names. So only in that part, it's counted as an exempt. But any anonymous donation otherwise, where the identity is not known or recorded, which will be known now from the Form 10BD, which we file, where the identification of the donor is given. So automatically the tax department will know that how much is the donation is given in 10BD and how much is anonymous. So if anonymous is higher than the limit specified, even though you have spent everything, tax of 30% will be applicable. Similarly, income from the property, which is either as a rental income or capital gains or anything in that part. Capital gain, I want to cover it very specific question. Like if any entity has a property and that property is sold for whatever reasons, under distress, under court direction, or by choice of the management of this thing, then entire capital gain is deemed to have been applied if the net consideration is again used to buy another capital asset. Not that you have put into any other OPEX, operating expense or anything. If you have bought another capital asset, then entire capital gain will be deemed to have been applied for charitable purpose. If it has not been done, then obviously the excess of the capital gain over the cost of old assets, capital gain will be counted as an income, and the income will be subject to tax. It will not be exempt. Again, the last column is very important, because that income from property held under trust created for charitable purposes, which tends to promote international welfare in which India is interested, is exempt. Where the CBDT gives a specific notification, but it in general will not be applicable to a general charitable organization, but it is just for the specific reference that such kind of a thing by CBDT, the notification is exempt. Next slide, please. Okay. One question comes to several charitable donations mind. Can they give donation to other charitable organizations? First and foremost is FCRA fund cannot be given to other other agencies who are doing the agency fund. So sub grant is not allowed in FCRA, which means sub grant can be given for a non-FCRA grants, non-FCRA funds, which means if you have a non-FCRA grant and you want to collaborate with other agencies who are specialized in that part, you can do a sub-agency with them. You can do a joint venture with them, so you both are putting together and doing that part, and it will be counted as properly spent as per the calculation of 85%. In that case, other agencies should give you a certificate of, again, utilization, like we normally give, so that your documentation is fully completed on application of funds. Just giving a mere donation from A to B will not be eligible, provided the other person is also spent it. Otherwise, the chain will create. A will give to B charity, B will give to C charity, C will give to D charity, and the very purpose of money going back to the society will be lost. I think I'm about to close my session in just 1 or 2 minutes by wrapping it up. My overview was that we should have a peace of mind in running any NGO activity. And a peace of mind means all compliances, knowingly and unknowingly, should not be left out. Some compliances by ignorance we choose, not choose, but we leave it out, may not have a very vigorous repercussions, but some non-compliance may affect your charitable status. Hence, it's very nice and very important to know what can affect you adversely and very badly. This session, otherwise, as first session was there, on the legal aspect was there, on the various legal aspects, so that you are aware of the legal framework. My domain was to tell you within that legal framework how to do, what to do, and how much time to do, so that you do not go back to the statutory authorities by losing your charitable status for which you were there. Thank you, Priya.
Thank you so much, Anil. That was so informative. And of course, Naushir as well. So I think since we're done, we're going to start with the Q&A session, which I think a lot of questions already have been coming in. Like I said, what I'll do is I'll start with the questions we had already received prior to the seminar. Benita, Anil, Naushir, please, feel free to take up any of these questions and also add to each other's answers if you want to. So first question being, what are the social stock exchange benefits and requirements for registration?
Maybe I'll answer that, Priya. So the social stock exchange is a very new development. This was first proposed in the budget of 2020 by the Honorable Finance Minister. After that, there have been several deliberations, etc. And right now, the Bombay Stock Exchange has made the social stock exchange a reality. Right now, it is open for registration. So you can go to the website. I'll share the link with Priya and also the contact of the person who is handling this. So in case you want to register first right now, after that, there will be opportunities for fundraising through this platform. So it's to be seen. First of all, a few disclaimers that no less than 19 countries have come up with social stock exchanges over the past 15-20 years. And not all of them have succeeded exceedingly well. India is a new entrant to this, and but we remain optimistic that it may become a platform for fundraising. What I find unique about the social stock exchange in India is that it has recognized social enterprises as for-profit or non-profit. The non-profit ones will be your trust society, Section 8 companies, and you might have a project that you might, let's say, hypothetically value at 1 crore of rupees, and there will be, in a sense, social investors who may want to pick up what is called a zero coupon, zero interest bond. It's a form of a grant, but I mean, there are these technical terms used for that, and you can break that up into pieces. I mean, so people can invest socially into that without expecting. The zero coupon, zero interest means that it's purely a social investment. There is no financial return that the investor gets. Where there are for-profit organizations, they will have to go through borrowing methods, investing methods, the normal investing methods. It's still work in progress. So just follow things on the social stock exchange website, and over time this will develop. So I'll stop at that.
Thank you, Naushir. My second question is, as a trust, what should be our position GST? Can we claim refund? If yes, for all amount or certain areas only?
Anil, you want to answer that?
Yeah, with your permission, I'll answer that.
Go ahead.
As I said in my presentation, that the GST registration is applicable based on the activity of the entity. So any refunds will come only if you are GST registered. And if you are GST registered, no refunds come. You are given inputs against your taxable turnovers output. So there are no refunds as such per se, which will come. You will be given an input credit like a commercial entity. And if you have a turnover, sales, and anything which falls under GSTable regime, where you charge GST to your service receiver or where you sell to the buyer, that time those inputs will be adjusted. If your inputs are higher than your such output, you will not get a refund. That will continue as an input credit. Now, one thing which is there is GST compliance has a lot of monthly compliances. So GST refund should not be the criteria to obtain a GST registration for any charitable entity.
Okay. Anything to add, Naushir?
No, that's good. I think he's covered it quite comprehensively. Thank you.
My next question is, I think Anil already covered this, but I'm still going to ask. Can one NGO give funds to another NGOs for ongoing training, monitoring, and assessment?
Anil, you want to go ahead? I'll add if they needed.
You please add.
Okay, there is, let me put it this way, that per se, one charitable entity can give to another charitable entity, but there are various parameters. This is thanks to different amendments that happen. Under a earlier amendment, one charity cannot give now corpus funding to another. That is one of the things. Second thing is, it must make sure that the objectives match. You cannot be an educational organization and trying to give to a medical organization. So, I mean, it must be seen that any funds that you're giving to another organization is in sync with your own objects. Therefore, in a sense, you are furthering your Another thing is, out of your accumulated income, you cannot be giving. That is another amendment that happened a few years ago. You remember, you are supposed to spend 85% of your income in any given financial year. If you are not, Anil referred to that form number 10, you have accumulated some income for a period of 5 years. Out of that income, you cannot pass it out. That has to be spent by your organization. You cannot say, okay, one way of spending it is, I'll give it, my organization is B, A, I'll give it to B, and I will show it as spend. So it is conditional. Yes, one charity per se can give to another charity, but under these conditions, not towards corpus, not from its accumulated income, and not towards corpus. Anil, if I have left out anything, let me know.
Thank you, Naushir. You have added very nice, important aspect for any entity to know so that they don't make mistake.
Yeah, thank you. Let's move on.
Thank you both. Next question. On a board of a non-profit, the founder is no more. There is no activity happening. What is the procedure to dissolve the board or pass on ownership? Can that be done?
It depends what is the structure of the entity. That's the first question I would like to ask the questioner. I mean, is it a trust? Because provisions for winding up a trust are not there under law. There are some provisions that have been made through amendments in the year 2070 for deregistering a trust in Maharashtra, but the process of winding up of a trust is not there. For a society, yes, you can wind up, but there is a procedure involved for that. A Section 8 company can also be wound up if you want. But ideally, you should try it. If the founder is dead, it doesn't mean the organization should die also with the founder. I mean, steps can be taken by whosoever are the surviving trustees left or directors of the company to ensure. But if you feel that, you know, there is no one to drive the organization, or the objective for which the organization was set up has failed, then yes, of course, winding up, or and now in Maharashtra, there are also provisions for merger of 2 or more trusts. So this is all very subjective, depending on structure of the organization, why this has happened. Ideally, you could perhaps take it forward, but if nobody is really willing to do that, yes, procedures for deregister or winding up also exist under law. So with that, I'll keep it at that.
Naushir, I'll just add one more thing here.
Sure.
Income tax 12A registration, when it comes with a condition that the entity is irrevocable, and if at any stage this needs to be wound up, the corpus or the money available in that trust should be given to another registered entity with a similar object. And once that is done, you can apply to the tax office for cancellation of 12A and ATG and everything. By that, that entity through income tax winds up. Maybe that entity continues because the bank account is also closed, income tax registration is closed, entity trust registration continues forever because that cannot be wound up, or society. But then that income tax provision allows you to close down the activity, deregister yourself, and give that money to a similar objective entity, and by informing them, close down the activity. Yeah.
Thank you. Very useful input. This is actually a provision that is mandatorily required in the constitution of a society. Usually,
right.
The last clause is the penultimate one is about, but the last clause is usually about winding, and even in a company, it is mandatory. In various trusts of earlier times, now income tax requires when you go for 12AB, you must have this winding up clause also.
Absolutely. Yeah.
So thank you for that, Anil. Useful input. Go ahead. Next question, Priya.
Thank you, Naushir and Anil. I think we have few hands raised. So before I get back to the chat box questions, I'll open the floor to anybody who wants to ask any questions. I think Shabanaji, you've raised your hand. I'll just ask you to unmute yourself. We can't hear you. You're on mute yet.
Now, can you hear me now?
Yes.
Please go ahead.
So in the deregistration or to transfer it to some other company that has the same values, what happens to the property?
You are referring to the immovable properties, I'm suppose, land,
Yes,
building,
that's right.
etc.
That's right. Yeah.
I mean, you have to pass a resolution in terms of every property, movable, immovable, which charity it is going to. You can get, but again, the transfer part will involve There'll be some stamp duties, etc., because you have to convey this immovable property to the other trust, etc. So there'll be where immovable property is concerned, the procedure will be even more elaborate, because, the property has to be conveyance, as we call it, in the name of the other entity. So there'll be some stamp duties, etc. It can be given by way of a gift to the other trust, but yet there'll be stamp duty requirements, so that the title of the property is given to the other entity. So it'll be more, but if where there are only movable funds, such as, liquid money, etc., then they can simply be transferred to the bank account of the other organization. Anil, anything you want to add to what I've said?
Absolutely, what you said is right.
Okay.
No, but see, this is my personal property that I have given to the society. Is there any way that after I pass away, the property then, because it was my personal property, it can go back to my next of kin?
Who's the title holder is the question I would ask. The property is a society. Is it the title holder is now the society? Have you given it as a way of a gift to the society?
Yes.
Then it is vested in the whoever are the members of the society, and your next of kin cannot really claim any unless it may be, of course, an illegal occupation, which may involve litigation, etc. But once you have duly conveyed the property to the society and the title holder is a society, then action needs to be taken by the managing committee to ensure that your next of your kin do not illegally lay any stake to this property. Anil, anything to add?
Absolutely.
Okay. Yeah, go ahead, Anil.
As he has rightly said, if you have conveyed the title, then all your rights have gone. If you have given only right to use, it's something else. So right to use is something else, where you are giving that until I am alive, you can use it. Then my next kid will allow you or not, that's a separate part. But if you have conveyed the title of the property to the society, then of course it is not belonging to you. You can't think of doing anything further on that property.
Okay, thank you.
Yeah, great. Okay, next question, Priya.
Anyone else who wants to directly ask a question, you can raise your hand and unmute yourself. Yes, Mr. Davinder, you can unmute yourself and ask. We can't hear you.
Hello.
Okay.
Is there any restriction on becoming a member, foreign members in managing committee of a trust? I am basically from Nishkam Sikh Welfare Council.
Particularly under FCRA, if your organization is registered under FCRA, the directive of the Ministry of Home Affairs is very clear that they discourage foreign nationals on the board, but they seem to be tolerating PIOs, or what we call as OCI, that is people of Indian origin. So there are certain declarations to be made in your FC forms in terms of when did you become an OCI, what's your address in the country where you have taken some citizenship, etc. So an OCI would be permitted. An NRI, of course, is an Indian passport holder, so that's not a question. But a ranked foreign national who is not even an OCI can have problems under FCRA. Your FCRA itself can be jeopardized if you have foreigners on your board. Income tax is kind of silent in this regard. Companies Act is again silent in this regard. Where states like Maharashtra, etc. are concerned, Charity Commissioner does make noises sometimes in terms of why do you have a foreign national on your board, because you're not supposed to do that. But even there, the Maharashtra Public Trust Act is also silent in this regard. Anil, anything you want to add to what I've said?
About Societies Act under the state?
No, it is not under Societies Act either. Who can be? I mean, basically, if you look at it, anyone who is in over the age of 18 can become a trustee, because this is very clearly covered under the Indian Registration Act, Indian Contract Act, that anyone who can contract, anyone who can be a trustee rather under the Indian Registration Act, anyone who can contract, and who is the person who is of sound mind over the age of 18. So those are the inferences that we draw under law. Okay.
Thank you, sir. Thank you.
Okay.
Prachur, I think you have your hand raised. You can go ahead. You can unmute and ask your question.
Yeah, hi. So we are thinking that if we need to set up a 501c3 in the US and we have a Section 8 in India, is there any sort of relationship between those two that can be established?
You may choose to keep it. I mean, whether the same name, etc. A lot of organizations now create 501c3 organizations. 501c3 is basically kind of a not-for-profit registration that you seek in the USA. One of the key reasons they do it is because there may be a lot of supporters in the USA who want to give you money, but are unable to get any tax deduction because, you know, if they are taxpayers in the US citizens, then your ATG is meaningless to them. They don't get a tax deduction, and ATG is given only to a taxpayer paying taxes in India. So when a 501c3 is created in the USA, the donors over there get a tax deduction, and then money can be sent to the entity in India, provided they have FCRA. The important thing is minus FCRA. If you create a 501c3, it is meaningless. So make sure lots of organizations, whether it is CRY, Concern India, a whole bunch of organizations have created overseas entities for this particular purpose. And yes, you may decide to keep an arm's length, or you may keep a connectivity. Either way, I mean, it's fine. It's the important thing is that the 501c3 complies with the laws of USA. And when the money is sent over here to India, your organization has an FCRA license to receive it. Those are the more important aspects.
Are there restrictions to the 501c3 spending money in India?
Not really. You have to be very clear. The 501c3 is again given to you if you have clearly stated your objectives in your equivalent of a memorandum and articles of association over there. And one of the things you would state that this is to support charitable activities in India, and that could be one of your objectives. And if the regulatory authority in the USA has given you 501c3 recognition under 501c3 is, by the way, given by the IRS department in the USA, which is the equivalent of our income tax authority. So if they have approved it, yes, I mean, there should be no restriction because your objectives itself say that one of the objectives is to promote charitable activities in India. Ideally, have a look at the constitution of some 501c3s already registered in the USA. And as I said, a lot of NGOs, whether it is a CRY or a Concern or a Eklavya, many of these organizations have their 501c3. So have a dialogue with them and see how they are functioning, and then you can take this forward. Anil, anything you want to add at this point?
No, I was just saying that since it's an entity registered for the US requirement, US laws, US compliance, so it's a independent of Indian compliance, Indian governance.
Absolutely.
It's running as it is, and it becomes a donor to Indian entity or directly through somebody else entity is a separate thing altogether. It has to see its own charter. It has to see its own condition of approval from the IRS, and based on that condition compliance, they have to do the needful.
I would
so there are no
also say,
restrictions on them spending whatever X percentages on contracts.
Neither Anil or I are experts on US laws.
Yes,
so
yes.
We will refrain
Better
from
to check
answering that.
Absolutely.
So, I mean,
Thank
we
you.
have some working knowledge at best. But I will give you one more option, that you need not necessarily create a 501c3 organization. There are even associations in the US. For example, one classic case I know is of an organization called Give to Asia. They are based out of San Francisco. They are a 501c3 organization, and they have a lot of partners in China and in India and Asian countries. So even entities, you have to first get registered with Give to Asia, and they will do a due diligence on you, whether you are registered, do you have accounts, do you have FCRA. And once you get registered with Give to Asia, then you can tell your donors abroad that give money to us via Give to Asia. Give to Asia deducts a management fee of less than 10%. So let us say somebody giving $100, you still get $90 in your account in FCRA. And you don't have to worry about creating a 501c3 abroad. You can do it through that. And it's a very established organization. I'm not at all even remotely involved with give to Asia. I only often advise them on legalities on FCRA, etc. But I know of their existence. So I need to point that out to you that you need not necessarily make a 501c3 also. Use existing platforms. It's their job to do that. But yes, there'll be a management fee involved, which the donors in USA are okay with, and you should be okay with. It saves you all this headache of running and looking after a 501c3. Consider that also as an option.
Sure. Thank you. Understood.
All right then.
Thank you, Anil and Nashir. Vinu, you also have your hand raised. You want to unmute and ask?
Okay. I have like two small questions. One is, can NGOs like take the services of another NGO as a consultancy? Like for instance, we don't have expertise in health and we need to do a particular project that needs a small amount of expertise on another area that we don't have expertise on, and we want to take the consultancy from that from the NGO for that particular piece of work. Is that possible?
Yeah, no, there's no law that stops you from doing that. We call it program partnership. Yeah, that, you know, I mean, you share your skills with each other. But is there any financial component involved over here?
Yeah,
Is the other NGO, so if the other NGO is charging you fees, etc., there might be implications of GST. Maybe, I'm just talking of a maybe. It all depends on the turnover of service involved. If the NGO has a turnover of service more than 20 lakhs, it needs to be registered under GST and charge you GST. It will become the commercial income of that organization. And the commercial income, if it is in the bracket of any other object of general public utility, it cannot be more than 20%. So it's conditional, but yes, you may seek the services of another NGO, but it's a very subjective answer that I would like to give.
Okay, just one more little question. Can an NGO which is not registered under FCRA can it do consultancies for foreign entities as an income generating thing?
It may be viewed by the ministry. If it is viewed by the ministry as a camouflage, a grant that is camouflaged as a consultancy, and many are doing that, there is a high risk involved. You have to see, I mean, many people feel now post 2020 that, hey, you know, I can't receive a sub grant, but you know what, I'm going to make this into a commercial contract. They take leeway under the loophole under FCRA, which says that any kind of commercial income, that is fees, etc., is not covered under FCRA. But please be very clear that if it happens to be a grant that you're trying to disguise as a commercial contract, Ministry of Home Affairs can come down on you like a ton of bricks. It has historically done that to certain organizations. So please be very careful. Is it in the normal course of you to be doing that? There are various parameters which cannot be explained in a short while on a workshop, but it's a very subjective answer I would give over here.
Okay,
Anil, 1 second. Anil, would you like to add anything to what I've said?
I'm simply saying that technically, yes, but as the subjective circumstances should not prove otherwise.
Absolutely.
Yeah.
Absolutely.
Technically, yes, you can give, but then the circumstance should not prove that you have camouflaged it.
Where FCRA is concerned, exercise abundant precaution always in every matters. I mean, it's one of the most, if I may use that term, a draconian piece of legislation. They can be quite ruthless in terms of, deregistering you, imposing huge fines and penalties. Most fines are in the range of 10 lakhs or 5%, 10% of the, for compounding, etc. And you don't want to go down that path. You had something to say when I interrupted you, ma'am. So you can go ahead to continue what you were saying.
Yeah, I was saying that, sometimes for a particular expertise, they also suggest that, they could do individual consultancies with, particular experts. So would that also be something that, one should...
What do you mean? What do you mean by individual consultancies? What is that?
What I mean is like a member of staff,
Meanwhile, I'll answer that. I understood that. You are just trying to bypass the FCRA and putting some of the staff on direct consulting contract with overseas.
You are right, Anil.
Yeah.
No,
so
we're not.
Yeah, tell me.
No, we're not trying to put it as staff under the other consultancy. That's
No,
but this is
staff
a
means
one-off thing.
that staff is billing overseas to get the payment directly into the bank account of staff.
Yeah, just for a one-off thing, for a one-off consultancy.
Whatever one-off, but that is between the staff and the entity. There is no NGO coming in between.
All right.
Please also
Fine.
understand that FCRA covers individual. Under FCRA, there is a definition of person. Person also includes an individual receiving foreign contribution for a definite cultural, economic, educational, religious, or a social program. So again, this is you're walking on thin ice. It's a subjective answer. Exercise abundant precaution.
Okay, thank
Let's
you.
move to the next question.
Thank you. I don't see any more hands raised. So I'll go back to the chat box questions. In the meantime, if anyone wants to ask, just raise your hands. The next question is, in a section 8, what are the requirements for board rotation? Does society need to renew after every 5 years? There are two questions actually. One is, what are the requirements for board rotation?
First of all, rotation part will be stated in your articles or the rules. In a society, usually it may say that you will have elections once every year or once in 2 years or once in 3 years. So follow whatever is there in your rules. Some societies I know have elections every year. Some have once in 2 years. Some have it once in 3 years. So that is, the law has not really put down anything. Under the Companies Act, a certain proportion of directors are supposed to rotate off, but they are eligible to be brought back on the board of directors. So once again, it is partly in terms of a voluntary kind of getting off, but you can be brought back. Anil, you want to add anything to what I've said?
You have rightly said, because the law does not prohibit anything on that part. It's more of a articles of association and the bylaws of your society, which is there.
Correct.
Yeah, I think a related question. Does society need to renew after every 5 years? Is this applicable to all the states?
In certain states, 5-year renewal is there. In Northeast, I believe there is an annual renewal process. So as I said, Societies Registration Act is a central law. Each state has its own modification. I have a suspicion, but I cannot say with certainty that Karnataka requires for every 5 years a renewal, but I can't speak with certainty. I have not studied the Societies Act in every state, but I know in Northeast, there's an annual renewal process that is needed. So that's the part I know about. So you have to check with your state what is the requirement. So you need to contact your registrar's office, the registrar of societies, and check in terms of all these compliance requirement, or download the bare act of your particular state, the Societies Registration Act, as applicable, let us say in Tamil Nadu or Karnataka or wheresoever. Yeah.
Thank you. Next question. In Mumbai, NGOs registered under MPT Act and SR Act 1860. Hence, is it called a trust or a society, or trust and society both?
Good question. A trust, if you create, will remain only a trust. But the peculiarity in Maharashtra is if you try to create a society, you'll be first registered under the Societies Act, and you'll also be made to register under the Trusts Act. You'll function like a society, but dual acts will apply to you. So nowhere under the Societies Act, it says you have to file change reports, but the Trust Act requires to do that. Nowhere in the Societies Act, it says you need prior permission of the Charity Commissioner to alienate property, but that is under Section 36 of the Maharashtra Public Trust Act. So there is one of the things I do, and I'm happy to make a disclosure on that. I usually recommend people in Maharashtra not to register as societies, because, you know, there is a dual registration required. And of course, there are certain kind of organizations where society may be necessary because you want to have members and a more participative kind of way of functioning. But if you're just going to be doing charitable activities, I would say, given a choice of society and trust, I would certainly recommend trust. It would be far more simpler for you. Anil, anything to add to what I said?
Nothing, because you are the master and champion from Maharashtra.
Okay. Okay, if you say so.
Yeah.
Next question. I think Vinu again has a hand raise. I'll go back to her. Vinu, go ahead. You can unmute yourself.
Okay. Sorry, this is about. Can you hear me? Okay. With the society, you have board members, and then they also form the AGM membership. Is it necessary to have like more members or other members also as members? Or is it okay? Is it
Entirely up to you. Entirely up to you. As I said, when you create a society, you need 7 members to start it, and who by default become the first managing committee of 7. Now, over time, your 7 may become 17, it may become 70, it may become 700 also. That's entirely up to you. These are members that will join as members by paying a certain membership fee. You may have various categories of members, patron members, ordinary members, people may be paying an entrance fee. Membership may also be a form of revenue for your organization, entrance fee, annual fee. Up to you. You may close membership, you may open it, but the minimum 7 is a requirement.
okay? So it is legal to just have the 7 people.
I've seen many societies who kind of have 7 members and usually 7 committee members. So basically, there's no distinction between the general body and the board. It's not the best practice, in my opinion, but well, that's how it is. Because in a sense, if you look at a Section 8 company, you might have 2-3 members, and they are by default the directors of the company. So, but technically, you can have very different members in a company, and your directors may be different. The shareholders need not necessarily be the directors of the company. So all these variances are there. Anil, anything to add to what I said?
Nothing. As you have said, it's a minimum requirement. Maximum you can have any. So
Yeah.
long as you feel that by adding members, your continuity of providing services is not hampered.
Correct.
Difference of opinion, difference of other things should not
Absolutely.
make the problem for you. If you feel the like-minded people can be not 700, go for it. But then it's no requirement.
Yeah, the point is, remember that the real power will vest in your general body. So, I mean, sometimes, if you have, as Anil said, 7 members, they can topple you also, and you may no longer be on the managing committee because you'll be outvoted.
Outvoted, yes.
That's
you.
the price we pay for democracy.
Okay, thanks.
Thank you, Vinu. I'm mindful of the time, so another 5 minutes, and then we are going to close the session. So anyone who wants to raise their hands and ask questions directly, please do so. Belu, you have your hand raised. Please go ahead. You can unmute yourself. Okay, we'll come back to you once you've unmuted. My next question is, do religious institutions like churches and temple need to have 12 AB and ATG?
Anil, just quick. I mean, okay, yeah. Anil, I think you go ahead. This is your income tax matter. Go ahead.
12A is definitely for any charitable activity you require it. And ATG is wherever you need that large people are wanting to have the donation benefit. So they can have the ATG so that they can issue receipt. Otherwise, the religious activity can have anonymous donation in any case.
I found that where ATG for religious institution is concerned, it is generally given to any religious institution which is of state or national importance. So you also have to prove that particular. So I mean, per se, every temple, church, mosque, gurudwara doesn't get ATG. You also need to be of some national, state, or local importance, and then income tax does grant you ATG. But ATG is a possibility. So, of course, it is the standard 50% tax deduction that the donor might be able to claim. Of course, if they put it in a hundi, they will not get ATG. It has to be any and it can't be cash over 2,000. So it has to be done by check or NEFT, etc. Because under the amendment that happened post demonetization, even cash donation about 2,000, it does not qualify for ATG.
For the donation, yes.
Yeah. So money is given in hundi or by cash will become non-eligible for ATG.
Yeah.
Okay.
Belu, you're allowed to unmute. If you are not able to unmute, then you can drop in your question on the chat box. I'll ask. Next question. Should we be taking utilization certification from individuals as well, whom we are supporting financially for animal welfare?
Under CSR, getting it is required, but otherwise, I mean, for individuals, a simple report is also fine in terms of how they utilize the money, etc. would be my view. Project utilization certificate has now become very important under CSR, where companies require NGOs. if money has been given, how the money was utilized. And this is usually done by a chartered accountant in practice with a proper UDI and etc. Anil could probably elaborate a little more on that.
As you have rightly said, normally the utilization certificate is in a format which is, because the government cannot check otherwise, so it's like a process which has been driven, that if delegated authority has verified it, so they consider that it has been given. So going to the ground level where the individual who has spent on the animal or something, it's maybe as a support function, as a report function, but that is not be counted as a utilization certificate as such.
Correct.
Okay. Second question, little bit related only. Do we need to do the investment from FCRA designated account, or it can be from a utilization account?
The law is a little silent in this regard. I mean, but just ensure that any interest, etc., that is earned enters into your FCRA designated account as far as possible. But if you have done it from a utilization account, then I guess by default it may go into your utilization, which is all linked up. But ideally, I mean, if you want to make an investment, as far as possible, do it from your main FCRA account is what I feel, which is with the State Bank of India, New Delhi main branch. And of course, preferably do it with State Bank of India only, so that, you know, there is, I mean, whatever is the interest, etc., by default will come in that account only. That's purely a recommendation. This is not a position under law. The law is silent in this regard, whether you can make FDs from your utilization or not. Anil, anything you want to add to that?
Absolutely fine. It's basically to have the peace of mind and keeping the thing simple.
Absolutely.
Do it that way rather than complicating it.
Because lots of things are ambiguous, and, you know, some officer sitting in the FCRA office just decides that, you know, you have violated the law and your trouble starts, you know, although your intention was not. So better safe than sorry is the general direction.
Absolutely.
Okay. The next question is in two parts. In a 4-member trust with a governing structure that empowers a 4-member management committee drawn from the board valid, or there should be a different structure applied? First question.
Answer, to give that answer, we would have to first look at your trust deed, what powers it gives to the board of trustees, the managing committee. So I would hold my answer in the absence of not having the trust deed before me, is what I would say. This is how we are legally trained. We do not give all these blanket answers without looking at the documents. Anil, what do you say? Yeah,
it's more of a transactional advice which is required. Assuming it was permissible in the trust deed, yes, it is possible. As simple as that. Absolutely. But that needs to be analyzed after seeing the provisions into the trust deed.
Absolutely correct. Because remember, your trust is governed by this document. You may call it the constitution of your organization, the trust deed. And every trustee is required, A, to follow the provisions of the law regulating you, and secondly, your trust deed.
Trust deed.
You may have provisions in your trust deed that I can invest in shares, but does the law allow you? Answer is no. So the law is the first layer. The second is your constitution.
Thank you. The second part of this question is, since the concept of members do not exist, can trustees still use the work member in their designation?
Work member, what is that? I mean, a trustee is a trustee. There's no other designation that you use. A trustee will always name himself or herself as a trustee. I didn't quite understand, what is a work member? What do you mean by that? Are you meaning to say that you are also maybe a staff member? Is this what you are alluding to? A trustee who is a working member also of the organization and therefore looking at salaries, etc. Again, the answer would be very subjective over here. As I said earlier, for remuneration purpose, there must be an enabling provision in your constitution. Any salary remuneration that you are giving is reasonable. But from a good governance perspective, and that's the topic I've covered, I believe somebody who's a staff who is also on the board is a bad idea. Board and staff should be, from a good governance perspective, the best practice. In the US, UK, it is unheard of that a staff member is also on the board. A staff member may be invitee on the board to guide the board, but they do not have voting powers, etc. So they are not technically board members. Maybe if that's the spirit of your question, then this is how I've tried to answer it.
One more thing I'll just add is, when he deals with an outsider, outsiders should get a right picture that he's dealing with a trustee.
Yeah.
So work member does not give the right picture of the person's authority. It has to be, if he's a trustee, so that the other person is dealing with a trustee. He knows his powers. He can sign up in a contract. He knows he can enforce it, but not with a work member.
Yeah.
Yeah, I think they've clarified. They meant that trustees still use the word member in their designation.
No.
No, I don't think there's need to use member. You just say, I'm a trustee of this organization. That's all. I mean, there's no question of saying I'm a member. I mean, even when you're on the government, I mean, you're a director in a Section 8 company, you don't say I'm a member director of the company. You just say I'm a director of the Section 8 company. Similarly, you say I'm a member of the managing committee. But yes, in a society, you would use the word member. I'm a member because you are either a member of the general body of the society or you are a member of the managing committee.
Yeah.
Ditto in a company, you may be a member of the member is the equivalent of a stakeholder in the absence of it being a company incorporated in such a way that there are no shareholders, but it is limited by guarantee. Then you can say I'm a member of this company, but I'm not a director. So there are all these nuances which don't want to make it too technical, but in a trust, please call yourself just trustee. Don't say I'm a member trustee.
Got it. I think we'll end the session, the Q&A session now. I think few hands. Shabanaji, you want to?
You want to wind up with 2-3 more? We can do that. But after that,
Yeah.
I think let's call a break. So yeah.
Go ahead, Shabanaji. You have your hand raised. We can't hear you.
No, can't hear. Maybe you should just put it in the chat box. No, can't hear you. Is there anyone else who we can hear? I mean, till he puts his question in the chat box.
Now, can you hear me? No.
Yes, yes. Please go
Yes.
ahead.
Okay. Now, I want to know, you said it's not a good idea to have a staff member as also a board member, but is that illegal?
If the staff member is drawing a salary and the income tax department says you are a board member who is drawing an unreasonable salary, it may not be illegal per se, but it may involve some tax issues over here.
But
There's
you
a
know,
lot
it's
of
a small,
background noise. There's a lot of background noise.
it's a small amount of money. It's like 18,000 rupees.
I will put it, I mean, nothing is small or big. I mean, any remuneration that you give, I mean, it has to meet the test of reasonableness.
Yeah.
Yeah, I would say from a good governance best practice, a board member should be on the board. Remember the governance pyramid that I showed you. There is a board, governing board, there is a CEO, and then there is a staff. Keep that bifurcated.
Shabanaji, Shabanaji, the issue comes on the tax department is by virtue of the powers as a director, are you trying to take some benefit even though whether it's a small or large?
Yeah.
So that becomes a questionable.
So you may be just open to more scrutiny is what Anil is saying, and rightly so, that you don't want to involve this. I mean, you want to be a worker, then just be a worker, don't be on the board. Or you want to be on the board and enjoy powers of a trustee, then be a trustee, don't be on a so-called work member. I mean, you can't keep one foot in this boat and another foot in the other boat. You can't. You got to be in one boat. That's all. So you decide what is best for you. Yeah. All right. We'll take one more question maybe and then wind up at 6:15. So
yes,
we can take just one last question and then wind up.
Yes, I have Belu's question with me on the chat box. If all the members of a society happen to be BPL category, is it mandatory for them to pay the membership fee? Can there be any exemption for the membership fee?
You can amend your rules in this regard if you want. I mean, membership is, you remember there are two parts to your charter in a society. There is what is called the memorandum part, which only has the name of your organization and your objects and who are the founders. That part is a little sacred, but the rules, you will find that usually the penultimate clause gives powers to the general body to amend the rules from time to time. So you can amend the rules to say people who are BPL need not pay membership fee, or they may only pay a token fee of 5 rupees or 10 rupees. Maybe I do feel that as a member, you can have a very token fee. Yeah, I mean, I'm sure even a BPL member would be happy to pay 5 rupees or 10 rupees, but put some value over there instead of just making it completely free. Anil, anything to add?
No, bilkul fine. It's like the school having an EWS category where they don't charge them the fees or just the tuition fee very minimal. And
Yeah.
that's a internal guideline regulations of the charter itself.
Correct,
Nothing.
correct. All right.
Thank you everyone. I'll just pass on to all the speakers and Benita as well for any end notes they want to share with the participants. And then we'll close the session. Over to you, Naushir, Anil.
I think the questions asked were very good. I mean, some of them were quite different from what I have encountered in the past. So I must say you have had I mean, it was a very enjoyable evening, and a wide gamut of issues were covered between Anil and myself. I was dealing with a very different part, whereas Anil was hardcore on compliance, which is a very much needed thing. I think the audience questions were very good. None of them were like, I mean, silly, if I may use that term. But although I'm fine with, I always make the disclaimer that there's no such thing as a silly question. If it's a question, it's a question. But I think the bar was high is one of the expressions I would like to use at this point. Anil, over to you.
As you have rightly said, the participation was very appropriate and elaborate. They were all, I must say, that very alert and kept them understandable. And from that point, and still if there is unanswered questions, they can still send the same to the iProbono, and then through iProbono it can be there.
Yes, Benita, over to you.
Thanks, Priya. Thank you, Anil and Naushir, for a very enlightening session this afternoon. We all really enjoyed it. And as the chair of iProbono in India, I found this really relevant to what I do as well. And thank you to all the participants for joining us and staying on so far in the evening as well. And as Anil and Naushir have said, please get in touch with us if there are any other questions that you may have. We will obviously be putting out some more information on this topic because we know this is something which is very close to all organizations, and this is something that all organizations are concerned about, and it keeps the CEO, the management team awake at night. So we'll certainly try our best to help. So please reach out to Priya and me. I'll put our email IDs in the chat box as well. And thank you so much once again to Anil and Naushir for a fantastic session. Thank you. Thanks, everyone.
Thanks everyone for joining.
Thank you, Priya.
Bye-bye.